Mr. Hill.
I was, just before the short adjournment, I was dealing with the judge's construction in his judgment on the election point. I just want to show you one other paragraph in his judgment. So we're looking in the core bundle, tab 7, page 129. The last paragraph I wanted to show you on the election point was paragraph 74. The judge says this: ultimately, this comes down to the words of the TTA. Those words contemplate its expiration on the 1st of September 2015. Just pausing there. That was the judge accepting the case that we looked at in paragraph 56 about it expiring or fell away in paragraph 56. He accepts that case in paragraph 74. So he says, those words contemplate its expiration on the 1st of September 2015 and crystallization of any payment liability under clause 5 referable to an election being made on or about this identified date. No other date or time marker appears in this agreement. It would require something strong in the admissible matrix or an intolerable commercial injustice or absurdity to modify the meaning of those express words. And that was his construction. Now, if one can, I just want to make a few final submissions in relation to the election point. If one can go to our skeleton argument, which you'll see in tab 3. We start our positive case on the duration issue at page 36, and we set out essentially 5 reasons why the judge's construction is wrong, and those reasons, 4 main reasons. And those reasons go from pages in the bundle 36 to 42, and I can't better what I've written, so I'm not going to laboriously read it out to you. Issue 1 is straightforward. I do want to just say something about, point 1 is straightforward. I do want to say just something about my point 2, which starts at the top of page 39. We say the judge erred in introducing this distinction between an informal election to sell or refinance to be taken on about the 1st of September, and then the sale and refinancing itself, which could be negotiated and take place later. What we want to highlight is this. Essentially, that does require a rewriting of the clause, because there's nothing in clause 5 that in any sense requires an election to be informally made. It's part 1, if one takes up clause 5, part 1 of clause 5 simply refers to the right to sell or refinance. It doesn't refer to an election that you are going to sell or refinance, as distinct from the act of selling or refinancing itself. And part 2, and this is perhaps the point to emphasize, part 2 refers to an obligation on John to pay a sum calculated by reference to the proceeds of the sale or refinancing. That is, the sale or refinancing referred to in part 1, and that crystallizes the completion and receipt of proceeds from the sale. That's crystallized by the completion and receipt of proceeds. So there's nothing in the words of clause 5 which suggests that the sale or refinancing in that part 2 can only be a sale or refinancing made pursuant to some earlier decision taken on precisely the 1st of September 2015. So the judge's construction just doesn't flow from the plain ordinary language of the words used in clause 5. And in fact, what it does is it requires you to read into the end of part 2 of clause 5 the words, provided such sale or refinancing is referable to an earlier decision taken on the 1st of September 2015. What we say is the introduction of this election concept is self-defeating. It's unnecessary and self-defeating. the judge's construction anticipates the sale or the refinancing happening after the 1st of September 2015. And therefore, it anticipates that something's going to have to happen with HSH, because the maturity of the loan was 1st of September 2015, and you saw my learned friend in front of the judge being asked about that. So necessarily the judge's construction requires there to be a hiatus period, because for all the reasons we looked at before the short adjournment, you can't sell the vessel and complete on the 1st of September 2015 if John is going to have a right of repurchase right up till the end of the Brandon loan. So it explicitly acknowledges that the parties must have anticipated the possibility, probably the likelihood, that the Brandon loan would either be restructured or somehow extended past its original 4-year period. However, once, and you'll know where I'm going now, once you accept that must be the party's premise, then that you might have the Brandon loan extended beyond its 4-year term without a sale or financing taking place on that day, then the entire premise for AF losing her right to indemnity on the 1st of September falls away.
What on the, I mean, in a sense, it's maybe a question for Mr. Kaplan, but I mean, what's the purpose of exercising the option, as making the election, as the judge put it, on the date? Is there then some time restriction upon how long it takes for you to actually consummate the sale? Or
in his judgment, no. So in his judgment, and that's why I took you to paragraph 74 of his judgment. He says, as long as it's referable, so as long as the subsequent sale is somehow referable.
So as long as you've chosen A or B, and thereby, as it were, foreclosed the possibility of, if you've chosen A, foreclosed the possibility of B, even if B turns out to actually be more advantageous in the future, you've got steadfastly just to pursue A at some point. Correct. What the judge has decided, as far as you say.
Yes, and he put to my learned friend the reasonable time point, which my learned friend didn't accept, because of course it's inconsistent with the language of clause 5. And the judge himself didn't then adopt his reasonable time point, because what he then does is he says it just has to be referable, and there is no time scale to it. And in fact, if one goes back and looks at the judgment.
Hence my question, in which case, if there's no time scale, etc., what's the purpose of making the election?
There is none. And there's 2 points I'd make for that. One is that what's the point? And to dovetail with that is, if you look the way the judge put it in paragraph 69, he said, and this is an interesting sentence, he says, at the end of 69, it is after all just an election. It need not even be in writing. So our response to that is, well, if it's just an election, it need not be in writing. He doesn't say it's got to be communicated.
Forget the writing, forget the communication for a second.
What's the point of it?
What's the point is rather what I'm trying to flesh out.
There is no.
It may be that it's for Mr. Kaplan.
It's not for me
to say, but let's assume just the brother says categorically, sister says categorically to brother, okay, I elect, it's a sale.
The short answer is that takes one nowhere, because until you actually get the sale or the refinancing, you don't get the crystallization of the loss. And it's not until you get the crystallization of the loss until the indemnity bites. So actually, it takes you nowhere. My second point on that was going to be, well, in any event, if you've now gone down the road of saying the sale or the refinancing doesn't have to take place on the 1st of September 2015, why is a sale in 2020 not a qualifying sale? If in fact it was the earliest time you could sell or refinance after having done the best you can to get the loan down, why isn't it? Put another way, the judge, because the election had not been a pleaded case, and my learned friend hadn't pleaded that you have to make an election, you never got any evidence about that whole issue about what would happen if an election had been made. And it is slightly unfair when my learned friend doesn't take up that case in closing submissions, and the judge comes to a case that no party pleaded or argued, and we haven't investigated whether you can actually say that she did make some sort of informal election in 2015, but the reality is she couldn't do anything about it practically until she actually sold the vessel when she did in 2020. Now, my learned friend, despite having said below that he wasn't going to adopt my learned friend's construction, he does obviously and understandably in his skeleton argument. Can I look at another point though in his skeleton argument on elections? If one looks to paragraph 53 of his skeleton in tab 4, what my learned friend does in paragraph 53 is he says, well, if the judge is wrong about his election analysis, the way he seeks to square the circle is to say John had to perform an election. So picking it up on page 71, paragraph 53, JF contingently also supports his original analysis that AF had to exercise her options, i.e. elect between them and complete the resultant process all before the 1st September. JF would say this is an equally viable construction of an imperfect instrument. In this eventuality, clause 1 would need to be interpreted so as to require JF to elect to exercise or not his buyback option a reasonable time in advance of the 1st September. That would be necessary to ensure that AF would have sufficient time in advance of that deadline to decide which, if any, of her options she wished to exercise and to bring that exercise to its fruition. That is a valid and workable approach to balancing the exercise of clause 1.
Or one might say it does more violence to the agreement.
Correct. And the fact that my learned friend has to put that forward, and that you are now requiring John, and they're running this for the first time on appeal, that John had to elect, 3 months, 4 months, 6 months before the end of the 4-year tenure, so that AF could then put in place a sale. The fact that he has to do that on appeal for the first time obviously shows the weakness of the case. Secondly, it's unfair, you can't run that on an appeal because he attended no evidence that his client did elect, and on that construction, unless his client elected, my client didn't have to do anything. So he can't run it on appeal. The further objections to it are, one, there are no express words that even suggest that John has to make an election. And secondly, you can't imply the words because they would be inconsistent with those express terms of the contract, namely clauses 1 and 5, which says he has a right to repurchase up until the maturity of the Brandon loan.
I can see it's open to an advocate to say there are 2 possible constructions, each of which are equally viable. Of course, that's not an option open to us. We simply have to decide which, if either of them, is correct.
Correct. There's only one correct construction. And the judge's construction doesn't work. And my learned friend's original construction that he put to the judge doesn't work for a whole host of practical reasons. And he tries to ameliorate the problems with that by putting forward this alternative construction case that doesn't work.
Well, these all, I think you would say, they all lead to dead ends. And it goes back to the simple wording of the clause, which is, after all, what we have to construe. One thing that is conspicuously absent from clause 5 is any explicit deadline at all.
And that's why I say, I start off by saying, our case is straightforward. We just apply the words. We say, you didn't buy clause 1, part 1 satisfied. There was a sale, part 2 satisfied. The sale was a 2020 sale. And upon that sale, the indemnity of part 2 is triggered. And I've just applied the words to the facts of our case. As I started out, it felt a long time ago now this morning, it's my learned friends who have to look at the factual matrix or elsewhere to try to read into this clause words that are not there. That's all I was going to say on the issue of the duration of the indemnity. Can I turn now to the durability issue as the judge described it, which is, does Angeliki have to remain the owner of Brandon? Now, the judge deals with this very briefly because it's essentially an obiter point by him, and one turns to his judgment, you'll see it at paragraphs 77 and 78, he deals with it. So perhaps if we can take it up at page 130 of the bundle and the heading durability of the TTA. In paragraph 76, he states the issue. In paragraph 77, he gives his reasons, and he's got 4 reasons, Roman 1 to Roman 4. And then in paragraph 78, he states his conclusion, I would therefore have accepted this proposition advanced by JF. And then if you turn over the page, he goes on to quantum. So he deals with it essentially in 1 paragraph. We make 6 points as to why the judge was wrong with respect to the judge. The first one is the obvious one. There are no words in the TT agreement capable of supporting a construction that you only have your right to an indemnity if you remain the owner of Brandon. There are simply no words. The words are not in clause 5. The contract simply does not say that clause 5 will only take effect insofar as AF remains the sole ultimate beneficial owner of Brandon. It simply doesn't say that. In fact, the ultimate beneficial ownership of Brandon is not referenced anywhere in the TT agreement at all, let alone in the operative clauses 1 to 5 or 1 to 6.
Sorry, say that again.
The ownership, the ultimate beneficial ownership of Brandon is not referred to in the TT agreement.
What about recital G?
Sorry?
What about
as control?
Well, okay.
But that's my second point. So shall I make my second point?
Okay.
What the judge does is he relies on recital G, which deals with control, not ownership. And that's important. The parties have used the term beneficially owned and beneficially controlled separately. If you look at recital A, when it comes to Shipping Fortune, which is John's company, they say it is beneficially owned by John. That's right at the beginning of recital A. Whereby in recital G, they don't say that. They say a company, Brandon, beneficially controlled. Now, just to point it out to you, clause 1 is the only other place where they talk about beneficial ownership. And in clause 1, when they talk about if John exercises his right to repurchase, it's to a company to be indicated to her by John or his heirs, as the case may be, either of his company, either of his or his family, control or beneficially owned. So there it's used disjunctively, owned or controlled. So these Greek lawyers, and there were Greek lawyers, in-house lawyers, did deliberately use a difference between beneficially owned and beneficially controlled to mean something different.
Or they may have used them as synonyms.
Sorry?
They may have thought of them as synonyms, given these are not concepts of Greek law.
They're not. Say for this, the word beneficially, I agree, is probably intended to mean ultimate beneficial owner. So therefore, in the concept, in this concept, the word beneficially is the same in both phrases.
I'm puzzling as to what is meant by the concept of beneficial control, as opposed to beneficial ownership, which we're all familiar with. Does it mean control, a power of control, but one you have to one you do not have to exercise in a fiduciary capacity, and can therefore exercise it for your own indirect benefit, or what?
I suspect the party certainly didn't consider that.
Well, we have to. I mean, it must mean something.
It must mean something. And our submission is beneficially controlled means she has the right to direct Brandon. Now, that's because if you look at clause 1, it's Angeliki in clause 1 irrevocably agrees that she will, so it's her, even though the vessel is owned by Brandon, she will consent to the sale. Upon the maturity, to accompany, will irrevocably agree, so it's her consent. She agrees to a sale. So she has, and because Brandon owns the vessel, she is the one that has to be able to ensure that Brandon can consent. Now,
I mean, unless she beneficially owns Brandon, a requirement, a fettering of her own directorial discretion or controlling discretion in the way that is the beginning of 1 would be a breach of duty, wouldn't it? She can't, unless she owns beneficially Brandon, how can she possibly agree that Brandon will simply sell the vessel back?
Because, for example, if she is, I mean, a good example is if she sells 1% of the shares. She sells 1% of the shares.
No, you're missing the point. Anybody who is a director or in charge or controlling, if you wish, directing the affairs of a company has to act in what you would assume to be the best interest of the company.
Correct.
And the only way of doing something which wouldn't be in the best commercial interest of a company is if you get the unanimous consent of the people who own the company. And on the face of it, the promise at the beginning of clause 1 is, I will agree that if you, Mr. Frangos, ask, that Brandon will sell the vessel back to you at certain prices. Now, unless you own the company, how can you just promise to do that? How can you promise to exercise your controlling or directorial responsibilities in that way unless you're sure that it's okay because it's your company?
I see the point. And I think the answer to that point is there were only ever going to be 2 interests in this vessel. It's hers solely, or as happened in 2017.
It was never hers solely. It was Brandon's, or it was
her interest in the company, not the vessel. The
Sorry,
company.
you said the vessel.
Oh, I do apologise. Sorry, I do apologise. The company. It was either her or in 2017 when she agreed that the shares would be held on trust for her and her brother. I anticipate that the parties never considered there would be a problem for her to be able to exercise her directorial discretion in the way in clause 1, because the only other possible owner could be the brother, who would be the beneficiary of that sale to him as required by clause 1.
Hang on. Wait. 2017. Sorry. At the time, we're looking at the time this agreement was entered
Correct.
into. Are you saying that in the time that the agreement was entered into, they already had in mind what would happen to it? So why is that relevant?
Because in practice, the only two people who would be ever interested in Brandon is going to be her and her brother.
Well, is there any evidence as to whether there's any thought that her brother would become interested in Brandon when this agreement was entered into?
Not at all.
Right. So that, by process of elimination, means that the only person that everybody envisaged would own Brandon would be her.
I think it's probably fair to say that at the time in 2011, people envisaged only she would be owning Brandon. I agree.
That it was her vehicle.
That it was her vehicle.
Her corporate vehicle.
It was her corporate vehicle, yes.
Okay.
And I agree.
So at the time of the TTO, everybody considered that Brandon was her corporate vehicle.
I think that's fair to say, yes.
Okay.
But yes. But what we do say is, even if you equate beneficial ownership to beneficial control to mean beneficial ownership. We say that doesn't take the position any further.
The reason we got into this is you made a bald submission. Well, sorry, not bald. You made a submission.
You probably thought it was bald.
Well, it was bold anyway. There was nothing in this agreement that indicated that your client was the beneficial, or that it required her to be the beneficial owner. Now we're sort of just going through the agreement and saying, well, what clause 1 appears to envisage is, as far as I can see it, is the parties envisaged that she would be the beneficial owner of Brandon, which would own the vessel.
Well,
at the time at which this option might be exercised in 2015, because otherwise it seems difficult to understand how she could promise to exercise her control directorial responsibilities in that way.
Well, my answer to that would be, of course, clause 1 doesn't require her to be the beneficial owner.
Well, but by implication it does, because how can she lawfully promise to fetter her discretion in that way in advance of the position that would occur in 2015?
My answer to that is, truth be told, whether she should or should not have, she did. She was happy to sign up to clause 1 that says she will irrevocably agree to the sale.
Isn't it the alternative? It suggests that everybody thought that come 2015 she would be, as indeed she was in 2011, still the sole beneficial owner and controller of Brandon.
Short answer, at the time, yes. At the time they thought she was, but I don't accept the second stage, and she would be in 2015, because I just don't, I don't accept that the words of clause 1 are sufficiently clear to draw that conclusion that it required, or the parties anticipated, in 2015 she would still be the sole beneficial owner of Brandon. The words just, we would submit it's just reading too much into those words. And one picks that up from clause 5. Let me explain this point. Because if one then goes to clause 5, all that matters here in part 1, if the conditions under 3 above have not been met and the vessel remains in the ownership of Brandon at the end of the 4-year tenure, and that is important, and that's the point I'm making about ownership and control. But I can make it in a different way. I can say, well, actually, what really matters is what the parties were really concerned about is Brandon owning the vessel. The Brandon owned the vessel right up to 2020 when it sold the vessel. Brandon always remained the owner of the vessel. That's what was necessary, if anything. If we're looking at whether the whole point of this is, did the indemnity lapse when she ceased to be 100% beneficial owner of Brandon? The answer is no. Why? Because clause 5 only requires Brandon to own the vessel. And you then move into part 2 of clause 5.
I'm sorry, Mr. Hill, before you do that, though, basically it seems as if Brandon and Angelica are used in some respects interchangeably, because if you look at that first part of clause 5, you've got the vessel remaining in the ownership of Brandon, but then immediately afterwards it's Angelica shall have the right to sell. And Angelica can't have the right to sell, Brandon has the right to sell, unless you're also looking back to say she is has beneficial ownership of Brandon. Otherwise, these clauses and clause 1 itself make no sense whatsoever.
I can see the force in that, and that's why we would say it turns on control. For clause 5, what matters is that she can control Brandon, and that she can, therefore, she has the right to cause Brandon to sell or refinance and what.
And presumably you would say as long as she has the control of Brandon, legally or beneficially, then we shouldn't be concerned with whether she's breached any fiduciary duties to Brandon or not. That's not on the face of this.
Correct. And as my lady just said, this is her corporate vehicle, or it was certainly at the time. And I'm not going to say any more than that, but the reality is, and it does dovetail in with part 2, who gets the indemnity? It's Angeliki gets the indemnity. And the reason Angeliki gets the indemnity is actually the very reason that the judge himself recognised. I was going
You're going to say she gets the indemnity because she has the guarantee. Okay.
Correct. And the judge himself recognises that. I'll just give you the reference to that elsewhere. I've just taken out, yeah, paragraph 48 of the judgment. So you just have a look at that. What he says in 48, he said, any underlying liability in this regard would have been owed by Brandon, the vessel owner, to MEM. This is the management company, rather than to AF herself. AF may feel such loss, but only reflectively as the ultimate beneficial owner of MEM. Since she is also the ultimate beneficial owner of Brandon, however, it means that she stood behind both entities on this notional actual ledger. The position differs materially from that governing the capital deficit, where AF was herself liable to HSH under a personal guarantee. This distinction adds a further difficulty to the putative characterisation of Clause 5 payment obligation. Now, I'll just see to it, and we don't need to worry about that. My point here is, the judge rightly recognised that AF required the indemnity because AF feels the loss. She feels the loss under her personal guarantee.
Would this clause still require payment to her if she had been discharged from her personal guarantee?
I haven't thought about that, but it might be that the words could be construed wide enough to do so.
Well, let me just give you the obvious example that at some point between 2011 and 2015, Angelika sells Brandon to somebody else. She remains in control of it because she's thought to be a good person to run a company, but she sells it to come to somebody else. And as part of the terms and conditions of the sale, as you might expect, she procures with the purchaser that she be released from her guarantee.
On those cases, that scenario, obviously, yes, because she's the one.
Are you saying that she would remain able to claim under this indemnity?
Yes, because she gave her personal guarantee to the bank. That she feels the loss directly. If it's hard to envisage this factual situation, but if she sells the vessel to a third party,
no, she sells the company.
Or if she sells the company to a third party.
Specifically, why I asked you about whether she sells the company, because we're here talking about the whole issue is we're talking about ownership of the company.
But even if
the vessel remains in the ownership of Brandon Maritime at the end of the 4-year tenure, but she's sold the company, Brandon, to somebody else and has procured in the meantime that she's off the personal guarantee because, as is usually the case on a company sale, the new owner would take over the guarantee.
Well, so sorry, on the facts of the hypothesis, you're saying that her guarantee is replaced with the bank, or is it that she gets a counter guarantee from the owner?
No,
because that would matter, obviously.
Yeah, but if we're sitting here, let's assume we're back with the parties while they're negotiating. Everybody knows that it is possible to sell a company, and if you sell a company to somebody else, it's very standard for the seller, who may have given a personal guarantee for the debts of the company to the bank, to come off, you've discharged from the personal guarantee, and the new owner, who buys the company, takes on a new guarantee
Correct.
to the bank. Right?
Yes.
So if that were to happen, what would the parties, so we'd have tapped the owners, the negotiating parties on the shoulder in the course of that and said, well, if Angelika is no longer the owner of Brandon and is off her personal guarantee because she sold the company, what's the result under clause 5?
I suspect if you tap them on the shoulder at that time, they'd say we'd have to amend clause 5 when that happens, because
We're asking you what clause 5 means. What do you expect is going to happen just before you sign? By the way, Mr.
This is
contracting parties. Can you just explain to us what you intend to happen in those circumstances under clause 5?
This is a hypothesis that obviously didn't arise, but my submission.
Well, but sorry, it did arise. Well, in the sense that we are asking the question now, probably not pre-2015, but at some point, Angelica has sold some of Brandon, as I understand it.
No, what's happened is the shares in Brandon. Sorry, I should have done this earlier. The shares in Brandon are held by MEH. MEH held those shares for Angeliki. In the 2017 MEH letter, MEH declares a trust and says it will hold those shares on behalf of Angeliki and her brother.
Yeah, so what was previously her... Okay, it's been done through the transfer of beneficial interests, but she previously was the 100% beneficial owner through MEH. The shares were in law held, as I understand it, you were told us, by MEH. Yes,
Correct.
Who held it on trust for her originally as to 100%.
Ultimately, yes.
And at some point holds it not for her as to 100%, but for each of them as to 50%.
Equally, yes.
So she has disposed of, or 50% of her beneficial interest in the shares of...
She has disposed of her right to... Well, the shares are still owned by MEH. She has disposed of 50% of her right to, say, for example...
50% of the beneficial interest in the shares.
Yes, but... What I say is, why she... Well, going back to my Lord Snowden's question, if she... The question is, your question was, if she no longer has a personal guarantee to the bank,
yeah,
because she's now got rid of it, which isn't the situation we've got.
No.
If she gets rid of it, then it may be that there is some impregnated, implied position that she has to be liable to HSH for the shortfall of the loan. That could be the position, but that's just so far removed from where we are now in this case. Because in this case, and this is a point I was making following on from the judge's point at paragraph 48, at the time they entered into this agreement, she feels the loss. And everybody expected her to feel the loss because she had the personal guarantee to the bank. And if I can just develop that point, if you sell a vessel that does not, if you have a vessel that does not meet its outstanding, that is not worth its outstanding loan, and it's making trading losses, the company, Brandon, is insolvent. When the sale goes through, the bank isn't going to look to Brandon to make up that shortfall. And obviously, in practice, it'll only consent to the sale because it's got a mortgage. It'll only consent to the sale if Angeliki makes good that loss under her personal guarantee. That is why Part 2 deals with her liability and it's her indemnity. It's an indemnity to her. So it doesn't matter. We say it's irrelevant who owns the shares, who owns the benefit of the shares in Brandon. The shares were always owned by MEH. It doesn't matter. The parties at the time realised that the person who's going to suffer the loss, feel the loss, is Angeliki under her personal guarantee for the shortfall. And the same applies for the trading losses, the accumulated trading losses. The vessel is part of the MEM fleet. It's the manager who is an unsecured creditor of Brandon. It is the manager who will suffer the loss because when this company is insolvent, it's not the shareholders who have to pay up. The people who suffer the loss are the unsecured creditors. MEH MEM, the management company, is the unsecured creditor. It is Angeliki's company and always has been Angeliki's company. She, therefore, reflectively suffers the loss. That is why the indemnity in Part 2 is to Angeliki, not Brandon.
Right, there were a lot of propositions rolled into that. If I can just unpick what I think I want to write down. I think what you're saying is the parties to this agreement would have assumed, the justification for Clause 5 giving an indemnity personally to Angeliki is that Angeliki would remain liable on a personal guarantee for Brandon's indebtedness. That's proposition 1.
Correct. It's fair to say I don't think the parties ever envisaged that her personal guarantee would go away before the loan was refinanced, because it goes hand in hand.
And is this right, that you say that the ownership of Brandon would be irrelevant because the parties were looking at a shortfall, and in a shortfall situation, that is, Brandon unable to repay to HSH because it has no other income, it's just a single person, just a company.
SPV, yeah.
The question of who owns it in terms of shareholding is irrelevant because the shareholders are not, as shareholders, liable to make good the deficit.
Correct.
So the reason that the indemnity was tied to Angeliki solely related to her status as personal guarantor. So the answer to my question earlier asked as to whether it presupposed that she remained liable on her personal guarantee is probably yes.
It may well be. The truth be told, I don't think anybody considered it at the time. Because, and let me explain why.
But we're trying to understand the justification for a structure to Clause 5, which is an unusual structure because it's talking about losses made to a company, a shortfall in the company's ability to repay its debt to the bank, but the indemnity is given personally to Angeliki, and that's what I'm trying to understand.
And that's why actually it's simply a payment obligation, and the judge made the point it's not an indemnity properly so called. Secondly, it's in that form because the personal guarantee was a term of the Brandon loan to the bank, and they will always sit together. Whilst that loan is there, is Angeliki's personal guarantee is there. When you refinance, obviously that personal loan goes.
Yeah, but my whole structure of putting to you the question of what happens if she had sold her beneficial interest in Brandon to another person and been released from her personal guarantee because the new buyer of Brandon had come on board and given a replacement to the bank.
It would have to be because of it's the latter bit. The new buyer would have to then give their personal guarantee.
Right.
And that's the trigger, not the change in share ownership.
Right, okay, but that's right. But in other words, the answer to my question of does it depend upon her remaining on her personal guarantee, I think is yes, isn't it?
All
right, well, anyway, I've asked the question.
Yeah, I will reluctantly say yes. The reason I say reluctantly...
Well, have a think about it. I mean, I don't want to force you into saying something
because,
without thinking if you...
No, the reason because it is a hypothesis that obviously has just been thrown to me on my feet, but it's not one that in the real world has happened, or I think the parties ever anticipated happening. The parties anticipated that whilst Brandon had the loan, her personal guarantee will be there. The Brandon loan, her personal guarantee and the Brandon loan go hand in hand. The only way you're going to break that or stop that is a sale of the vessel, and therefore the loan gets repaid, or refinancing and another refinancier comes in. And that is why the indemnity is to Angeliki personally. She suffers it in relation to her personal guarantee. She suffers it because MEH, in terms of the operating profits, accumulated losses, MEH is an unsecured creditor of Brandon. Brandon is MEM, I do apologise.
I was going to say MEM, the
MEM,
the management company.
management company, is an unsecured creditor. And just like we said that the shareholders of Brandon don't have to make good the shortfall or to the bank, the shareholders of Brandon don't have to make good the debt owed to MEM, the management company. And that is why she, in relation to the accumulated losses, is the beneficiary of the payment obligation, the Clause 5 indemnity.
Okay, I think we need to move on.
I do. I think actually that deals with all of the points I was going to make on that. Can I just take 1 minute? And that deals with that point. That deals with that point. I've made my 5th point. I'm just going through the points in the skeleton. I think I've made them all now. The only one that I haven't perhaps highlighted is the capricious nature of the judge's construction, which is hard to see why she would, but say in year 2, year 3, she sells 1%, 5% of the company, or gifts the shares to her niece, or something like that. She ceases then to be the sole beneficial owner, if that's the correct requirement, of the shares in Brandon. But it's just capricious. Why then should she lose, by doing that, the value or the benefit of the indemnity? Makes no sense. It's capricious.
In those circumstances, it's difficult to see that she has the right to sell the vessel because she doesn't own beneficially Brandon. So one is in a deeper mire than that.
Save that if you are the 95% shareholder of and she's gifted 5% away to her niece. The reality is...
You say beneficial control.
It's back to your beneficial control. And but there is a reason why they said control rather than ownership. There's a reason for that, we say. Can I just take 1 moment, if I could? That's all I wanted to say on the durability issue. On the respondent's notice, I'm not going to deal orally with the implied rescission cases because we have set out our position very fully in our written supplementary skeleton, and at the moment there is nothing to add. What I will do though now is sit down and let Mr. Feld address you on some points on quantum arising out of respondent's notice, because they do dovetail with the questions the court has just been asking me for the last 45 minutes. The quantum points are relevant because they dovetail in with the durability question. And Mr. Feld will make those submissions.
Thank you.
So I'm dealing with the 3 points in paragraph 3 of the respondent's notice, which we've dubbed quantum, but all of them essentially concern the second sentence of clause 5. So that's behind tab 8 of the core bundle, page 141. And so that clause after the comma contains the payment obligation, which is that John hereby irrevocably and unconditionally guarantees the payment to Angeliki of any such shortfall and accumulated losses. So each of these points concerns the sum of money represented by the words any such shortfall and accumulated losses. We say that sum of money is 11.6 million. I need to point out for your Lady and Lordship's notes that there's a mistake at paragraph 3 of our appeal skeleton. That quotes a figure of 11.8. And that's the same mistake that the judge made in paragraph 1 of the judgment.
So please tell me again, it's 11...
It's 11,664,290, and the correct figure is at paragraph 21 of our appeal skeleton and in our appellant's notice. The 11.8 was the original claim and it was reduced by amendment. Now John says it should be presumably less than that figure, but he doesn't tie himself to a figure. The thrust of two of his submissions are that there just needs to be a further trial to work out what the shortfall and accumulated losses or agreement.
So you may have claimed originally 11.8.
Yes, I can show that
But-
why that is.
But you don't need to. But it for the purposes of your appeal skeleton, paragraph 3,
Yes.
we'd say AF now claims.
Well, we amended before trial, so we
Okay.
claimed at trial.
Okay. Now and since just before trial, but for our purposes now, it's 11.64290.
Yes, and that's based on updated accounts from Brandon, essentially.
11.664.
It's 11,664,290.
Yeah.
And obviously these issues only arise on the hypothesis that we're successful on the primary construction issue. So it arises on the hypothesis that the sale and refinancing in part 1 can occur after the 4-year tenor, and indeed in 2020. And secondly, it's on the hypothesis that my learned friend, Mr. Captain, is wrong that it was an essential predicate of clause 5 that Angeliki remained the 100% owner of Brandon. So with that in mind, I'm going to deal with the respondent's notice, the 3 points, but it's important for us to set out where we get our positive case from. So our position is based on 7 points on the construction of clause 5. So the first, which it doesn't appear to be disputed, is that the words any such shortfall and accumulated losses refer back to the words behind the comma, to the starting stanza of the second sentence, if the proceeds from the sale or refinancing are not sufficient. The second point that follows from that is that there are therefore 3 quantities that define the sum payable. So what we need to do is the sum payable is the difference between, firstly, the proceeds of sale, and secondly, the aggregate of the outstanding indebtedness to HSH and the losses from the operation and management of the vessel. Those are the 3 quantities. Now, one can categorise it as the shortfall being the difference between the proceeds and the indebtedness, and then you add on the accumulated losses. Or one can actually say that shortfall and accumulated losses, and this was my Lord Snowden's point at one point, that that's actually one concept, one item, which is the difference between what you get for the vessel and the aggregate total losses. We submit that's the right way of looking at it, and there's actually one figure in Brandon's accounts that represents that, but the maths is the same whichever way you do it. So that's the second point. The third point is that there's no issue between the parties as to how you calculate proceeds of sale and the outstanding indebtedness. There is an issue as to when you calculate them, but no issue as to what they mean. So that just leaves losses from the operation and management of the vessel.
Sorry, so there's no issues in how you calculate the
Proceeds from the sale or refinancing,
proceeds.
and there's no issue about the outstanding indebtedness to HSH. There was a trial, but there isn't now.
I mean, is that sum done anywhere visibly in the papers?
Yes, it is. I will have to remind myself of where that is. It will be in Mr. Marax's evidence, but the sum I think is common ground. So we know it's 4.6 received, and the shortfall is 1.8 or 1.9. It's in our skeleton argument. I don't think there's any issue about what the shortfall was as of July 2020.
Okay, so is it paragraph 18G of your skeleton?
That sounds about right, my lord. I have to check. Yes. And I'll also say that there's no issue about the numbers in 2015 either, because that's one of the points that's taken. So it's not disputed, it wasn't disputed at trial, that the value of the vessel in 2015 was 9 million. And the outstanding indebtedness as at September 2015 was just the balloon payment in the Brandon loan, which I think is 19.1. But I'll come back to that. So then, fourth point, on losses from the operation and management of the vessel, it's common ground now that that refers to loss made by Brandon and not anyone else. So at trial, John made a case that ultimately responded to loss suffered by Angeliki. That's not the case anymore. He accepts that that is the loss suffered by Brandon. Fifth, on losses from operation management, at the risk of stating the obvious, that's the losses from the operation management of the vessel, which is Taurus 2. And it's defined in recital A as the vessel. So not any other vessel, just Taurus 2. And the sixth point, and again this might be common ground, is that losses here is not losses in damages. So we're not comparing the financial position of Brandon but for some harmful event. It's losses in profit and loss. In other words, it's the amount by which the accumulated cost of trading the vessel exceed the accumulated revenue generated by the vessel.
So it's a trading loss, in other words.
Yes, yes, my lord.
When you say it's from trading the vessel, do you mean it's operational trading as opposed to financing costs?
No, we would include financing costs. Well, this is going to come back to, this is the point you dealt with Mr. Hill, that actually it's either it's shortfall or accumulated losses, but shortfall and accumulated losses will include financing costs, depending on whether they're paid.
So these are losses suffered by the company Brandon from trading the vessel?
Yes, my lord, but given that Brandon is a one-ship company, and all it does is acquire the vessel, service the financing, and bear the costs of trading and receiving.
I'm just trying to, in a very simplistic mind, I have company has vessel, company charters out vessel, receives fees, has to pay employees, taxes, upkeep, maintenance, fuel, blah, blah, blah.
Financing costs.
Well, no, don't put the financing costs in just for a second.
Yes.
Just the costs that are associated with actually physically operating a vessel.
Yes.
Right, so that's what I'd call operating costs, trading costs. The financing costs incurred to the bank on the company's indebtedness, you'd include those together with the first category of what I'd call trading or operating costs.
Well, my lord, if they're capitalised, as in they aren't paid and they form part of the outstanding indebtedness at the time when the vessel's sold, then they probably technically fall within shortfall. If they are paid, they are effectively the costs, the real costs of trading the vessel. So in order to acquire a profit-earning chattel, one has to finance it, and when you work out whether the chattel's made any profit, you have to look at the cost of acquiring it. Now, one might include, we're getting into the realm of accounting, one might even include the depreciation of the vessel as part of the operating costs. But it doesn't matter because the depreciation either comes in as operating costs or it comes in as shortfall, because the depreciation is the capital loss that's crystallised when you sell it or you refinance it. So this is why it is all ultimately shortfall or accumulated losses. But the point is, the financing cost is a cost borne by Brandon, and it's a cost that falls within shortfall and accumulated losses, one way or the other. And this is my seventh point, which is that it follows from all of the above that you'd expect to find, and indeed you must necessarily find, the quantification of shortfall and accumulated losses in Brandon's audited accounts. And that's because Brandon is a one-ship company. It doesn't do anything other than own and trade the vessel. It's the borrower under the loan, it's the seller of the vessel, the recipient of its proceeds, and it's the party that's liable for the costs of having the vessel. So ultimately, one way or another, the number is in the accounts, and then it's just a question of accounting practice as to which number one takes. And that's important on the Triton 3 submission. So then looking at the accounts, we get the figure from the 2022 accounts. Now, we originally based it on the accounts of July 2020, which is the time of sale. And then what happened is some of the trade debt got written off before trial, basically. And so we gave John the benefit of that. So we're looking at the 2022 accounts, but actually, strictly speaking, it should be assessed as at 2020. And they're in Supplementary Bundle Volume 2, tab 31, page 617. the figure there is total equity in the left-hand column towards the middle of the page, 11,664,290. So that is the single sum. So that includes both the capital shortfall that was covered personally by Angeliki, to the tune of 1.8 million, and then what we say are the accumulated losses, which is 9.7, I think. Yes, 9.77. But we say it's one figure. And that makes intuitive sense because total equity is just retained earnings less the starting equity. So that's the share premium, which was contributed by Capt and Frangos. And retained earnings is just the sum total of the profits and losses since the company acquired the vessel. So it makes sense that that figure 11 is the total shortfall and loss. The other way it makes sense is it works on a cash basis as well. So if one looks at that figure 11,664, that is effectively the 11,941 amounts due to other parties.
Sorry, just pause just for a second. What's the note 514? Because that isn't the amount of. That is
no. So 7.8 was the figure.
Yeah.
6.69 or 6.7 was treated as an equity contribution to the vessel, and the remainder was to pay down the vessel's trading debts as they stood at the time of the acquisition by Brandon. So it was a total contribution of 7.8 million, but the parties divvied it up as.
Oh, sorry, I'm just not getting this. The Captain Frangos, Nikolaos Frangos,
Yes.
paid $7.8 million US
Yes.
to HSH.
No, I think he paid 6.
Well, I'm only just reading recital I to the agreement.
Yes. Has been paid by funds to HSH. Yeah.
Are you saying that that was contributed to the company? But if it was contributed,
Well,
if he subscribed for share, because note 514 says that it's the company's shareholders that have contributed $6.7 million.
yes. So the Brandon acquires the vessel for 33.5 million.
Yeah.
Some of which is contributed, an equity proportion of which is contributed by Captain Frangos. The rest is a loan from HSH. Now, when paying to HSH, that purchase price may have been when buying the vessel, that purchase price may have been paid directly to HSH because it served to reduce the original £47.5 million loan.
Okay.
But it's accounted for in Brandon's accounts as an equity contribution because it's funding towards the purchase of the company's only asset.
Yeah, but by somebody who isn't in fact a shareholder or indeed beneficially. And
Well, it's the share capital of 10,000.
yeah, but he's not a shareholder.
No, he's not a shareholder.
Do these accounts identify who the shareholder is or the ultimate beneficial owner?
I will have to come back to your lordship about that. But it's common ground that it was that Angeliki is the sole shareholder.
Anyway, okay.
Thank you very much. 620, I'm told. Yeah, the company's wholly owned by Maritime Enterprises Holding.
Right.
That's
Yes, but it's okay. It's not. It's wholly as a matter of shares are owned by
MEH, and MEH's shares, I believe, are owned by Angeliki.
Okay, and so there's. I see how $6.7 million is accounted for. I'm just not sure where I get where the other 1.1's gone.
Yeah. Yes. So, I mean, this is dealt with in the evidence and trial. I'm not sure we've got all of the evidence in here, but if one looks in the core bundle, basically the agreements behind the Taurus 2 agreement, tab 8, there's this recitation of the terms of the bailout. So, tab 8, page 143. So, number 2, the purchase price was to be financed by 6.7 equity from the buyer and a loan with the balance.
basically. Just give me the reference again.
Sorry, yes, it's tab 8 of the core bundle, page 143. And then item 5 is undertaking by the buyer to pay all current trade debt and costs incurred to the special survey of the vessel past. So the vessel, while under arrest, had an accrued trade debt of 1.1 million. That's cleared, and that was 1 million. So the total provided by Captain Nicholas was 6.7 plus 1.1. And I don't believe any of this is disputed. So the difference between the loan, the Brandon loan 6.8, and the purchase price 33.5 is 6.7 million. That's the equity contribution. So where I was on total equity in the supplemental bundle. And I'd mentioned that it was retained earnings less the capital. The other way to get the same figure is to look at the only current liabilities, which are 11.9, less the current assets, which is 276. And if one looks at the notes there, 5.11, if one goes forward to...
Sorry, I'm sorry to be really thin about this, but the retained earnings are of 18,364,290 are the accumulated losses made through the operations of this company over the period of time since it was formed.
Since it owned the vessel, because it did nothing else, it was formed to own the vessel.
Right.
Yes.
So yes.
So, and one can see that if one looks at the difference between 11,884 in the previous period and 11,664, the difference is actually the income for the period, which is 219 on the page 616, bottom number in the left-hand column. So it's just the sum total of the profits and losses over time.
Yeah, but the sum total is 18,364. That's the losses which it's made. It's reduced to 11,664 because you have burnt through share capital first.
Yes.
So if you were taking, I thought I'd written down that you were taking us to this to show us the accumulated losses.
Yes, my lord.
So why are you saying the accumulated losses are 11,664?
Because the way it works in accounting terms is effectively the company's in the black at the start, has a notional equity.
It has an actual equity.
But it has an actual equity in the vessel of 6.7. And so it's only once that's gone that one gets to zero, and then thereafter everything is lost. I mean, I'm making this submission. The way where I'm getting to with this is just to say that this was all made good. This 11 figure was made good by the evidence of Mr. Miraculous at trial, who's MEM's accountant, or finance director rather. And the point really is to say that none of his evidence was challenged in cross-examination. No points were taken on accounting practice, and indeed my learned friend in his written opening disavowed any points about accounting practice, and there was no expert evidence adduced to challenge either the accounting practice or the accuracy of these figures. But the one other point I just wanted to show you in the accounts, because it feeds into the other points that have been made, is if one looks at the current liabilities of 11.9 million, note 5.11. That's on page 634. What one sees is the accumulated losses on a cash basis are the current liabilities, which are either the amounts due to the company, to the management company, MEM, 9.1 million, amounts due to related parties, which is all Angeliki, 2.835.
So which?
Sorry. We're at page 634, first hole punch. So I'll start again. Let's go back to 617. What I was saying is that the total equity figure, I'm trying to make good that it's a representation of loss. And what Mr. Miraculous says is, not only does it make intuitive sense in terms of it being accumulated losses and retained earnings, it's also equal to the accumulated losses on the cash basis. i.e. it is equal to the difference between the outstanding liabilities of 11.9, and one sees that in the figure of 11.9 in the current liabilities section, less current assets at the top, which is 276,000. And while we're looking at those figures, I wanted to make good the assertion that all of the losses are ultimately funded either by Angeliki or by MEM, and one sees that in the note to the current liabilities, which is note 5.11, which is on page 634. And that shows that that figure for current liabilities is comprised entirely of the balance due to MEM, the management company, representing payments made by the management company to cover the operating expenses of the vessel, and 2.8 million, which is directly funded by Angeliki. 1.8 of which was the capital payment to HSH, and the rest is her contribution to the operating expenses. So as I've said, all of that was made good in terms of being the number as amount of accounting practice by Mr. Miraculous. And I say it's too late now for my learned friend to challenge that on appeal. Firstly, because he didn't do it below. He didn't cross-examine Mr. Miraculous about this, but also because he doesn't have any evidence to challenge that. So with that, I can now turn to the 3 points in the respondent's notice. The first one is the temporal limit point. There are two strands in John's reasoning. The first strand is the pure point of construction. So John says that even if a sale under the first sentence of clause 5 can take place after September 2015, and in this case in July 2020, you've got to read part 2 so that the shortfall and accumulated losses are assessed or capped as they stood at September 2015. Now, pausing there, assuming that's right, which it isn't, but assuming it's right, it's not in dispute that had there been a sale in September 2015, there would have been an even greater shortfall in accumulated loss. It would have been about 15 million. And that's comprised of a much bigger capital shortfall, 10.6 million compared to the 1.9 million that was actually suffered, but a smaller accumulated loss. So there would have been about 4.5 million of trading losses at that time compared to the 9.7 million in July 2020. Now that brings us to the second strand of the reason.
Can you just go more slowly for a second? You said there had been a larger capital shortfall of what?
10.6 million, which is the difference between the value of the vessel, 9 million, and the outstanding indebtedness in September 2015, which is the balloon payment of 19.6 million.
Yeah.
And that compares with the much smaller capital shortfall in 2020 because Angeliki got HSS to write off so much of the debt. And there would have been a slightly smaller accumulated losses, so that the accumulated trading losses in 2015 are somewhere around 4.5 million. Probably would have been greater, but the figure we have for the 30th of July 2015 is 4.5 million, and we're content to take that as the conservative estimate.
So July
2015. And that's Mr. Miraculous's first witness statement, paragraphs 14 to 15. I don't need to show it to you, but that's the evidence. So that's smaller than the accumulated losses as they stood in 2020. And this is the second strand of John's reasoning, which he says he can have the plum without the duff. So he says there'd need to be further agreement or a remission back to the commercial court to determine what the loss is. But he says it's possible to assess the accumulated losses part in 2015, but it's not possible to assess the shortfall because in 2015 there hadn't actually been a sale and so no loss was crystallized. So he says he can have the smaller accumulated losses, but doesn't have to pay the bigger shortfall. So that's the second element of his reasoning, and that's paragraph 83 of his skeleton. So we say both strands are wrong. taking first construction, we say it's abundantly clear that the clause requires the shortfall and accumulated losses to be assessed as at the date of the sale. So we bring up the clause. The premise here is that the qualifying sale under the first sentence occurs in July 2020. So then the next question is, if the proceeds from the sale, so the proceeds from the sale has to be assessed as at July 2020, and then the clause requires you to ask if they are sufficient to cover the outstanding indebtedness and the accumulated losses. So it seems obvious that if one is going to make that comparison, one has to look at the shortfall and the accumulated losses, the outstanding indebtedness and the accumulated losses at the same time as the proceeds. And there are two further linguistic points that make that clear. The first is, in the first sentence, that the sale is in order to cover the then outstanding indebtedness. So when one looks at outstanding indebtedness in the next thing, it's obviously outstanding indebtedness at the time of the sale. And if that's right, the same must follow for accumulated losses. The second point is that if one is looking at the proceeds of the sale in 2020, but the indebtedness as it stood in 2015, then that denudes the word shortfall of meaning, because there isn't really a shortfall. One's not comparing, one's not actually looking at the difference between proceeds and debt. And actually, my learned friend praised that in aid in his second strand of reasoning, and he says, aha, there's no shortfall. But that just shows why the construction's wrong, because it doesn't give any effect to those words. So we say it involves rewriting the clause to say outstanding indebtedness to SHH as it stood in September 2015, and operation and management of the vessel only up to September 2015. And the second point is, when we get to this stage of the argument, there is just no basis to do such violence to the terms of the clause, because of course this proceeds on the hypothesis that the indemnity was engaged by a sale in 2020. And if there's no reason to read down the scope of the indemnity at all. So that's all we have to say about the temporal limit. It just doesn't work with the words of the clause. The next point is the Capt reflecting Angeliki's share of ownership of Brandon. And I say essentially this stands and falls with the points that have already been made, but I will deal with it in terms of quantum. So this involves rewriting part 2 of clause 5 to say, John hereby irrevocably and unconditionally guarantees the payment to Angeliki Frangou of such shortfall and accumulated losses as represents the proportion of her ultimate ownership of Brandon. That's what needs to be read into the clause. And that's the extent of the violence that needs to be done. We have 4 short points on that. First, the construction is incompatible with the words of the TTA, and notably, neither Mr. Captain nor the judge made any attempt to try and justify this quantum construction, this limitation of the amount of the indemnity by reference to any words in the contract. Secondly, if we get this far into the argument, there's no reason to do the violence. So we only get here on the hypothesis that the premise is that there's 100% ownership. Third,
sorry, I don't understand that last point.
Sorry, we only get here. Sorry, I didn't finish the sentence. That's why I didn't understand it well. We only get here on the hypothesis that the premise of my learned friend's construction, which is that it's an essential predicate to the agreement that Angeliki remain 100% owner of Brandon. We only get to this quantum level argument if that premise is false. Now,
okay, yeah, because it's actually, I'm going to at some point come in and will tell me when you want me to deal with it. But the point you've made, the point that does arise, which has been illustrated by the submissions you've just been making, is that at the time of the sale in 2020, Angelika had negotiated with the bank such that the bank had agreed to accept less for repayment of its loan, so the shortfall was quite small. Mm-hmm. But the accumulated losses, so that, as it were, her, if her being on her personal guarantee is the thing that makes this clause commercially work, it's a small shortfall, which you can say, yes, that in effect represents what the bank would go to her and ask for, as guarantor. But to the extent you're looking at accumulated losses, you are looking at the accumulated losses of a company,
yes, Lord.
which has no connection with her status as a personal guarantor anymore.
Yes, my lord. And so we do need to deal with that. And actually,
Yep.
it's not all based on the personal guarantee. I think we've got to make that clear. So what I will say is there is this awkward fact of the agreement that it doesn't require payment to Brandon. As your lordship points out, it requires payment to Angeliki. The question is, what are the consequences of that? Now, what my learned friend says is, well, then you need to adjust it to reflect her ownership of Brandon. And that all proceeds on a false premise, which is that AF feels the loss qua shareholder.
Yes, but
Yes.
you see,
But it's not just qua personal guarantor. This is what I come into.
okay,
She feels. Go on.
but why should you be compensated? I mean, if she remained 100% shareholder of Brandon, I would understand why you'd say, well, she has to be made whole in two respects. One is shortfall to the bank because she might get called on the personal guarantee, and the other one is a company which she owns 100% has suffered losses because it stepped in to help out over
Yes.
a period. And even if the bank hasn't claimed it from her, her corporate vehicle has suffered accumulated losses.
Yes.
And so brother ought to make sister whole in relation to both those
Yes, well.
amounts. But if she doesn't own 100% of the company which has suffered the accumulated losses,
Yes.
what's the rationale for paying her?
Precisely, my lord. And this is the difference.
And that's
That's what we've
the
been
question.
going round and round doing. This is the difference between ownership of one ship company and the management company. And this is very important. So the premise there is that actually you own a company, the company suffered a loss, you've got to pick up the tab, so you should be compensated. That's not right. The loss of a one-ship company is felt not by its shareholders, but by its unsecured creditors, and the parties would necessarily have contemplated, with or without personal guarantee, that Angeliki would ultimately be, or would have to make good the unsecured creditors. Now, I'm going to unpack that. The first point is, a one-ship company that suffers the type of loss identified in this clause.
Sorry, so just to make sure, the assumption is that the shareholder would have to make good the unsecured creditors.
No, not the shareholder. That Angeliki, because she is the driving force, she is the owner, she is the management company. So it's the management company that is always going to be the unsecured creditor, and Angeliki is always the one that's going to have to make good the losses of the management company.
Which she wholly owns.
She does. She does. But and I hear this. I hear the response, which is that, well, hold on, why does she have to make good the management company any more than she would do a one-ship company? But the difference is a management company isn't just a one-ship. The management company is the trading face of the fleet. So the management company manages all the vessels in the fleet, and it's the outward-looking. It's basically the commercial face of Angeliki, not the one. The one-ship company doesn't do anything apart from hold the asset. And okay, yes, it bears the losses, but it bears the losses by virtue of being charged back by the management company. The management company is doing everything commercially. So that's a very different proposition for that going under compared to the individual vessel not being profitable and being insolvent. And so the commercial reality was, and everyone understood, was that management company would always ultimately be funded in the event of a global shortfall by Angeliki. But just to break it all down, the first point is that the losses, a one-ship company that suffers the loss envisaged by this clause, i.e. where the amount it can get for the vessel is less than the amount it owes for the vessel and its trading losses, by definition that company is insolvent on a balance sheet basis. Then the next question is, when a one-ship company is insolvent because it's loss-making, who picks up the tab? And it's not the shareholders, unless there's been some misfeasance. The whole point of having the one-ship company is to insulate the shareholders. So the tab is always going to be picked up by the unsecured creditors.
The unsecured credit, it's not a question of, I don't know what you mean by picking up a tab.
Sorry, well, the loss is going to be ultimately suffered. The hit is ultimately taken by the unsecured creditors. Because there's a deficit, there's a cash deficit, as you see in the accounts of unpaid creditors. And it's them that are effectively funding the loss. Because they're the people that are out of pocket.
Right, okay.
and they don't have recourse to the members.
That they won't get paid, put it that way.
They won't get paid.
Yeah.
Thank you, my lady. Yes, well, this is the third proposition, which is that the unsecured creditor, at the end of the day, is going to be the management company. And we deal with this in relation to in our skeleton, in relation to the 2018 reconciliation. So for the note, it's in our supplementary skeleton at paragraph 20. But effectively, the management company is like a pooled bank account. So what the management company does is bear all the costs in the first instance of the vessel, and then it charges that back to the ship-owning companies via reconciliation. Equally, it takes all of the hire. Well, the hire gets paid into an earnings account with HSH. Once HSH has been paid its loan costs, then the excess hire goes to the management company. So it's actually the management company that's running everything, which is why ultimately it is always going to be paying any shortfall. And the reality is, yes, Angeliki was always going to be so she will partly be an unsecured creditor by virtue of her personal guarantee, but ultimately she's always going to be feeling the loss by virtue of the management company, even if there wasn't a personal guarantee. And actually, that's exactly how it happened. That's why I showed you in the account that it was so that all of the loss is borne by the management company.
Do we have any evidence, did the judge have any evidence about her beneficial ownership of the management company?
Common ground.
I held that it was common ground.
She's 100% owner of the management company.
We'll have to look overnight.
Yes, if you
and
would.
see if we can find some references, Your Ladyship.
So you're so, but I mean, basically, what you're saying is that in the event that there is a crystallizing event, sale, there will only be. Sorry, it's not. There will always be. There was, but it would have been envisaged that there would only be one creditor of Brandon, because what would happen was that the bank would, which is the creditor of Brandon, would call on Angeliki on her personal guarantee. She'd pay. She'd have a right of indemnity against the company in respect of the payments under the personal guarantee. And the other unsecured creditor would be a management company which she owns.
Yes.
Because that, in practice, defers all the operating expenses on behalf of Brandon.
Precisely. The management company is like a wrapper for the trade creditors.
And is left as the unsecured creditor. So whether, ignoring for the just present purposes the corporate entity,
yes,
you'd say Angeliki would suffer the loss of this. If there were losses to be suffered in this scenario, she'd suffer it in two capacities. One is as owner of the management company, which is left as the unsecured creditor, and secondly, it has somebody with a right of indemnity having discharged her personal guarantee with the bank.
Precisely.
And this was designed to catch both.
Precisely, my lord. And that is the driving force of Angeliki being paid, not the fact that she's the shareholder of a one-ship company, by definition, insolvent one-ship company. And so, my learned friend's solution is the wrong one. The whole idea of her shareholding in Brandon is a red herring, because that's not what's driving her being the party that gets paid. Right, so now that leaves me with 5 minutes to deal with Orion 3. Which it might be best to come back mainly and reply if we have any left by the time I finish talking.
I mean, what I'm still not quite clear about, though, having said that, is how the figure that you showed us, which is the net trading losses of Brandon, net of its share capital and share premium account, in fact, fits the explanation you've just given.
Because when one looks at where that 11.6 million, where is it in cash? 11.6 million is the difference between all the money it owes, and it only owes money to Mem and Angeliki. So that's all the money that they've spent defraying its costs and charged back to it, less 200 grand that it's owned by John. So ultimately, all of that loss, ultimately, the loss as it stands after it sold the vessel is just the negative figure on the balance sheet, the difference between current assets and current liabilities. And all of the current liabilities, the net current liabilities, are debts to Mem and Angeliki. Yeah. I'm going to have to go back through the numbers again. Tab 31 of the supplementary bundle. I mean, it might actually, perhaps we can look at it in...
It's just the number doesn't quite add up, does it? That's all. It's just I can't reconcile.
Yeah, so
you
might be worth looking at Miraculous 3, actually, because he gives the evidence about this. So, paragraph 16 of Miraculous 3, so that's tab 15, page 221.
Supplementary 1, haven't we?
Supplementary 1, yes.
Page.
221.
Thank you. Sorry.
So, the audited accounts confirm that Ms. Frangou and Maritime at MEM have advanced amounts to Brandon totaling 2.835 and 9105640. Which, if you add together, are slightly more than 11.6, or 276 grand more than 11.6. So then he says, if you add, so yeah, you take those two numbers, you add them together and you add the equity, which is 6.7, that comes to 18,641, and the difference, which is the same as, which is a little bit more than total equity, and the difference is the amount due to Brandon. So ignore the shareholder equity of 6.7 because that's on both sides of the equation. What he's saying is that if you add 2,835,000 at 9,105,000, and you deduct the sum of money so the sum of money in which respect to which Brandon is a creditor, sum of money owed to it, which is 276. You add those three figures together, you get to our 11.6.
But you don't. You get to 11.9.
Ah.
You do.
So I need to double check the maths.
Well, you get to the number, which is shown in note 4.5 to the accounts, which is the sum of the two numbers that you identified at page 634 of 11.941 million.
Yeah. Yes, but then you need to deduct 276,000 from that. Yes.
And that is what is said.
That's what he said. It's three numbers, not two numbers. So you add the two. You add the 2.8 and the 9,105. Add together to the 11.9, which is the total liabilities. And then you've got to deduct an asset, a debt owed to Brandon of 276 from that. And that gives you 11.6 million.
Is that to 276920 referred to in paragraph 16?
That's right. And if one goes back to note 5.11, so that's page 634. So the three figures he refers to, Mr. Miraculous refers to, are the 276 figure is amounts due from related parties at the top. The amount of 276,920 is due from First Lines and other entities related to John Frangos. And I believe that's basically cash that was taken out of the company. Then you have the second figure is 9.105 million, which is amounts due to the management company. That's by the first hole punch. And then you have amounts due to related parties, which is the 2.835. And that's what you see on the balance sheet.
I think we'll have to move on,
Yes, please.
if and to the extent that it's necessary, perhaps my Lord Justice Snowden may ask you to produce a little note about that if he wants it, but I think we need to move on now.
So, yeah, I'm grateful for the indication. So Orion 3. So the case is slightly difficult to follow, but as we understand it, what John is saying is that the current claim fails to take into account, as he says it should, profits made by a company called Trinite in respect of a different vessel called Orion 3. And he says that Brandon was either entitled to or did receive benefits from Trinite out of Orion 3's profits, and that the total equity figure I've shown you, or the figures in Brandon's accounts, don't reflect those benefits because they make no provision for Trinite's status as a debtor of Brandon, he says in his skeleton. And then he says that there needs to be further agreement or a remission to the commercial court to work out what the profits are once Orion has finished the current charter. Now, it's protested in John's skeleton argument that this is all about construction, and we say that can't be right, because it's, as I've already taken you to, it says losses from the operation and management of the vessel. It's got nothing to do with Orion 3. And secondly, it's common ground that the arrangements by which Orion 3 was bought and cross-collateralized with the Taurus 2 post-date the Taurus 2 agreement by some time, and they weren't in contemplation when it was entered into, so they can't possibly factor into the construction. So the real point is about the evidence, and we've summarised what we see the logic as in paragraph 33 of our supplemental skeleton. There are 4 premises. The first point is that it said that the audited accounts are just a proxy or an estimate of the accumulated losses. Secondly, that Brandon either actually received benefits from Trinite's profits, or at least was contractually entitled to them. Thirdly, that the receipt of the money or the entitlement to receive it is not reflected in the audited accounts. And 4, the value of the benefit can't be known until the end of Orion 3's current fixture. We say all 4 points are wrong. Firstly, there's no question of the accounts being a proxy. We say that the figure I've shown you in the accounts is the accumulated shortfall, sorry, the shortfall and accumulated loss by definition. It is the sum total of the costs of running the vessel less the profits, together with the capital loss suffered on sale. Put another way is, what other evidence would one expect other than the audited accounts? My learned friend can't now challenge Mr Miraculous' evidence on why that's the right number as an out of accounting practice for the reasons I've already given. So point 1 failed. Point 2, I say there's no evidence, in fact, that Trinite was actually obliged to pay anything to Brandon out of Orion 3's profits. Still less evidence that it did, and in fact it's clear that there was no such transfer. Now that's disputed, and I'm going to have to look at the documents, which are quite involved. So I'm going to come back to that. But we say there's an even shorter answer, which is the 3rd stage, which is that if my learned friend is right, if it's really right that Trinite provided benefits to Brandon, or if Trinite was a debtor of Brandon, then it would be reflected in Brandon's audited accounts. I mean, these are audited by Grant Thornton. So if Brandon's debt to HSH was somehow discharged by a payment from Trinite, that would be reflected in the accounts. If Trinite's profits defrayed Brandon's operating costs, that would be reflected in the accounts somewhere along the line. And if Trinite was a debtor of Brandon, if Trinite owed, by way of contribution, some money from its profits to Brandon, then that would be an asset on Brandon's balance sheet. So ultimately, this whole submission boils down to requiring my learned friend to show that Brandon's audited accounts are not properly prepared or don't give a true reflection of its financial position. We say that's just not open to him now. He doesn't have any evidence to make that good, and he didn't take it at the first instance. Yeah. So that takes me back to the 2nd stage, which is whether any of this is actually right on the facts. It involves looking at some documents, so we'll come back to it in reply if we need to. But the point is that the actual loan documents, which are quite involved, they show that the profits from the Orion 3 were in fact used to pay down the Stiliani loan. That's very clear in the document, so we've given the references in our skeleton argument. But I'm not going to do that now given the time, so I'm going to come back to it and reply to the extent that I have to. That just takes me to the final stage of the reasoning, which is that we can't quantify the reduction for Orion 3's profits until Orion 3 completes its current fixture. And we say that's completely wrong. Firstly, the assessment of the shortfall and accumulated losses has to take place as at the date of the sale. So if my learned friend's right about the profits, you just look at whatever had been paid by Trinite or was owed by Trinite as at that date. You don't look past the date of the sale. And we say that's all the more so because, in fact, this whole cross-collateralization scheme, which I haven't been able to take you to, but it ultimately came to an end at the same time that the Taurus 2 was sold. What happened is the Taurus 2 was sold, and that paid off the Brandon loan with a bit of shortfall. And at the same time, broadly the same time, Orion 3 was refinanced, and that paid off the Trinite loan and the Stiliani loan, and it all came to an end. So the end point on any view is July 2020. But I'll have to come back to it given the time. So, my lady in-laws, those are my submissions on the consequence.
Thank you very much, Mr. Fowle. And rather late in the day, but nevertheless, Mr. Capt.
Good afternoon, my lady, my lords. I'm going to take the appellant's notice points first and start my submissions by addressing you on the TTA itself and how it works. And my lords, the TTA is behind tab 8 of the bundle. And my lords, here I'll be developing my written submissions on the TTA's basic anatomy, as I termed it, paragraphs 38 to 40 of my skeleton. Now, the first thing I want to show you is who the TTA is putatively between. And there you'll note at the top of the page, Captain Nicos, the father, was an intended party to the agreement, as well as Miss Frangou and Captain Frangos. Now, in the end, Captain Nicos never signed the agreement, although if you turn over 2 pages to the signature page, you'll see a space was left for him to sign it. And my lords, the significance of the father's putative involvement in the TTA is that it reinforces and underscores the imprimatur of the father that the judge lighted upon, and his very significant role in brokering the bailout, and the inability to divorce what Captain Nicos would have expected and been happy for the siblings to agree from the likely meaning of the TTA. My lords, this lends support to the importance of the family aspect of the bailout as being relevant background to the TTA's interpretation. And I'll address you more on the family background tomorrow. Moving on to the recitals, which come under the heading of background, which I would suggest indicates this is a good part of the document to look for relevant factual matrix. In recital A, in the first 2 lines, you see that it's recorded that the TT is owned by Shipping Fortune, a company beneficially owned by Captain Frangos. This is pre-bailout. So the fundamental starting point that we move forward from is the TT previously having been beneficially owned by Captain Frangos. Then recitals B to D record the initial financing of the TT by HSH and the problems that ensued leading up to the TT's arrest. You don't need to look at them further. Recital E records the preliminary agreement between HSH and Miss Frangou as to how, as the recital puts it, Shipping Fortune's default with HSH was to be sorted out. And I pause there just to note the word sorted out. They're a rather colloquial way of explaining what happened with the bailout, and perhaps indicating that the precision or formality of language in this document was not as high as it would have been had it been drafted by native English speakers, of which none of those involved in the preparation of the document were. And my lords, that may be relevant in particular to how one reads references to beneficial control and ownership in the document, which I'll address you on in the context of the durability construction arguments. Recital E, that we're talking about, cross-refers to attachment number 1, which you can see at page 140 of the bundle, just behind where we're looking, inside this tab. So this document was appended to the TTA. And so I submit continues to be admissible matrix to the TTA's construction. And there's 2 points I want to draw out from this document, which predates the TTA. This is one of the initial emails in which the terms of the bailout being discussed between HSH and Miss Frangou were being explored. And bullet point 1 of this email, HSH writing to Miss Frangou say the premise of the bailout is a company representing the interests of Miss Frangou, the buyer, will buy the Taurus 2, the vessel, at a price of 33.5 million. So I say this demonstrates two things. The words representing the interests of Miss Frangou are indicative of concepts of ownership by Miss Frangou rather than control. And you also see the very clear premise of the bailout here, that it was Miss Frangou that was buying the Taurus 2. Although the company was in effect, was in substance buying it, Miss Frangou is behind the deal. And the second theme from this document that I want to draw your attention to comes from the paragraph 2, the end of the second line going into the beginning of the third line. You immediately see, even at this stage, reference to the 15-year profile of the loan and the 4-year tenor, and that's repeated at paragraph 4 of this document. So, and as I'll come on to when we look at the agreement in detail, the pervasive theme of the TTA is this 4-year tenor of the Brandon loan. This is the backbone of the agreement against which all of the rights and obligations, we say, need to be judged and understood. Back to the TTA on page 139, and we move on to recital F. This refers to the final settlement agreement between HSH and the old borrowers who had defaulted on the facility, and that was concluded on the 31st of August, the day before the TTA is dated. And you're referred to an appendix 2 there, which isn't actually behind this document in the bundle. That's the standstill agreement, which my learned friend took you to. I don't need to ask you to turn that up. But what I would ask you to note in terms of dates is that the standstill agreement and the Brandon loan were concluded on the 31st of August. If you just turn back for a moment to the email I was asking you to look at from HSH to Miss Frangou, that's dated the 26th of August. And my understanding from the evidence at trial was that Miss Frangou first started talking to HSH about the bailout for the first time on the 23rd or the 24th of August. So the whole process of conducting this bailout of in excess of $45 million default, from initial contact with HSH through to the conclusion of a complex suite of documents affecting the bailout, takes less than 10 days. And my lords, I would say that was clearly a fact known to the parties when the TTA was concluded, given the documentation appended to it and the background. And that length of time would inform the parties about how long it might take for any refinancing effected in accordance with Clause 5 to take if and when it was required. So we're talking in terms of days, not the months or an incredible complexity that my learned friend would ask you to.
Oh, sorry, I'm not sure I follow that. You've got a lender dealing with the Frangos family, and in effect the lender is prepared to accept an approach from sister to assist the brother who's in default. I can fully understand that might go quite quickly, given that they're both, as it were, established and the family is known. If you've got a new lender, a third party coming in, a new institution who hadn't previously had any relationship with the Frangos family, then I'm not sure that would follow, that the same time scale would apply. You could have a very different time scale.
I accept that. The only point I make is that what is not a simple deal here, the restructuring of an over $45 million default, has been sorted out, as the parties refer to it here, in the space of about 10 days. And that might just be one indicium that the parties may have had in mind when thinking about how quickly or not quickly things might have transpired at the end of this agreement. I don't put any...
Okay, all right. But I mean, it would. I think the only point I'm making is that this has been sorted out, as it were, in the family, if I can put it in the colloquial nature, because I don't know whether SH have relationships with Captain Nikolaos Frangos as well. Sorry, no, not Captain Nikolaos. Captain Frangos, the father.
Nikolaos, yes.
Yeah. So, yeah.
So I wouldn't want to detain you further on that point, but in my submission it doesn't support the idea that months and months would be required to perform something similar at the end of the agreement. Over the page in the TTA onto recital G, and this is particularly important for the durability constructions, and that's one of the planks that the judge relied on. This records that the TTA has been sold by Shipping Fortune to Brandon, and it's stated to be a company beneficially controlled by Ms Frangou, and we say, as the judge found properly viewed, this means either beneficial ownership or rolled up into it beneficial ownership and control. As you were discussing an argument with Mr Hill earlier, beneficial control isn't a concept easily recognised in English law, and the word beneficial famously goes alongside ownership, as it was used by the parties appropriately in recital A. And we say, allowing for the fact that the draftspeople did not speak English as a first language, it's quite fair to give this phrase the meaning for which we contend, particularly against the importance of Brandon being owned by Ms Frangou that one gets from the background of the bailout, as the judge found it to be, and as I showed you in the documents earlier, the whole premise of the bailout is that the company goes from the ownership of, the ship goes from the ownership of Captain Frangos to Ms Frangou. And I'll come back to this in more detail when I address you on the construction. The second point to note from recital G is the explanation of the Brandon loan towards the end of recital G, including its 4-year tenor and 15-year profile. And my lords, you'll note here that the purchase price is some 33.5 million, but the loan amount is only 26.8 million. And this clause records that the purchase price is thus paid only partly by way of the new lending, the Brandon loan. And as you were discussing earlier, the rest of the purchase price for the vessel comes from most of Captain Nicos's 7.8 million cash injection, which is then recorded at recital I. And as you were discussing earlier, was affected in some ways the provision of share capital to Brandon by Captain Nicos, perhaps on Ms Frangou's behalf, or our shareholder. My lords, I pause to note here that Captain Nicos, the father, is the only person to put any cash into the bailout. Ms Frangou does not put in any cash, and as I come on to, permanently takes the benefit of Captain Nicos's cash payment after 4 years have elapsed. So via the bailout, Ms Frangou gets the TT into her ownership from Captain Frangos's ownership without spending a cent. Now, if the TT remains in negative equity, that still doesn't work out very well for Ms Frangou economically because of her personal guarantee over Brandon's debt to HSH. However, if things change and that negative equity position is overturned, Ms Frangou has got a vessel in a company that she wholly owns without spending any money whatsoever. So the bailout is not entirely without commercial merit for her.
Wait a minute. She has to put herself on the hook to the bank for a substantial indebtedness which she didn't previously guarantee in relation to a loss-making vessel. I mean, that's a pretty big investment, in inverted commas, that she's making. I mean, the suggestion she's just sitting there getting the benefit of $7.8 million is a little bit far-fetched, if that's what you're trying to say.
I'm saying that in substance, she is benefited by that payment at the end of the 4-year tenor, because she does not have to pay that money back. And had that payment not been made...
Yeah, but it's like... But she's put herself on the hook for a personal guarantee to the bank. I mean, the 7.8 is gone. But if it hadn't been there in the first place, assuming that the bailout would have gone ahead in any event... Well, that's a big assumption. Well, my lord, in my submission, that is the assumption that one should make. The bailout is going to go ahead. Captain Nicos contributes some money towards it to get it over the line as a sweetener. But if he wasn't going to put the 7.8 million up, but had otherwise instructed Ms Frangou to go ahead with the bailout, which is part of the factual matrix that the judge, as the judge found it, she'd been instructed to do this, she didn't want to do this, then she has, in a sense, been benefited by that payment, because otherwise she'd be underwriting a loan here of 33 million, the purchase price of the vessel. Well, no, she wouldn't be underwriting a loan of anything. She'd just be sailing off into the sunset, to coin a phrase. If the bailout wasn't going to go ahead without the father's 7.8 million, but
But the starting point of my submission that she's benefited by this payment is that the bailout would go ahead, whether or not he made it or not. And if he hadn't made that payment, she would be the one underwriting a loan for the full purchase price of the vessel, not just, let's say, 3/5 of it.
But we don't know, do we? We don't know whether it would or wouldn't have gone ahead, save that. You tell us that the evidence was that she was instructed to do it by her father and didn't want to do it. But she was instructed to do it by her father on the basis that he was putting the 7 million in. So we can't speculate about that at all.
I accept that, my lady. Recital H we can skip over. And recital K is, it records that the management of the TT were now vested in men. This is the vessel manager that you were being addressed on earlier. And recital K is important background context to this agreement because the effect of this vesting of the management in men away from Captain Frangos' management is that he loses control over the vessel, day-to-day control over how it's traded. And that's critical when one appreciates that to a certain extent, Captain Frangos is under Clause 5 underwriting the economic fortunes of a vessel that he no longer has any control over whatsoever, against the backdrop of an up to...
So which Captain Frangos?
Captain Frangos, the participant to this agreement. When I refer to the father... when I refer to the father, I'm going to refer to him as Captain Nicos.
Sorry.
And when I refer to the son, I'm going to refer to him as Captain Frangos.
Yeah, sorry, you just said Captain Frangos, so that's why I was just trying to make sure.
Yes, sorry, the son.
Yeah.
So Captain Frangos is, under Clause 5 of this agreement, effectively underwriting the economic fortunes of a vessel that he no longer has any practical control over, or any control over whatsoever, against the backdrop of an up to 19-year period of the vessel's future trading life. And my lords, one question to ask yourselves is what is inherently more likely to have been the longevity of the indemnity he promised to provide? A short focused one over the 4-year period of the Brandon loan, during which time he had an option to buy the TT back, and Miss Frangou was locked out of dealing with the TT. That's our case. Or in Miss Frangou's case, Captain Frangos provided an indemnity unlimited in time, up to 19 years, that was basically incalculable in amount, with the only knowable backstop being around 2 decades worth of trading lifetime across the vagaries of the chartering, ship sale and ship finance markets. You say that's most unlikely stepping back once you've absorbed the agreement in its proper context. My lord, it's that from that platform in the recitals that we move into the substantive clauses in the contract. Those are just clauses 1 to 5. Clause 6 only concerns governing law and jurisdiction. So, my lords, first on to clause 1. Now, this is Captain Frangos'
The argument against you on that last point, I think, is something like this, isn't it? Your client is very keen to retain the possibility of getting the vessel back. He resented having had to give it up, and the intervention of the bank. The price for having the opportunity to buy it back in 4 years' time was that he would have to indemnify his sister for however long it took for her to be able to sell or offload the vessel thereafter. Why should it be a one-way street? In other words, that he has the option to buy back after 4 years, and if he says he doesn't want to, he also doesn't have to do anything to see his sister made whole as a consequence of the risk that she's taken on to give him that opportunity.
Well, as I'll come on to, in our submission, the way to read the interplay between clauses 1 and 5 is that clause 1 is the primary clause in this agreement. It is the purpose of this agreement to enable Captain Frangos, the son, to have a right to buy back the vessel. And the judge found, as admissible matrix, he was very concerned about that, and that was the instigating factor behind this agreement being concluded in the first place.
But the primary purpose of this agreement was to bail out.
Well, that is to elide the bailout with the TTA, and they're different things. The bailout happens before the TTA is concluded. And our position below, accepted by the judge, was that the bailout effectively was going to happen come what may. The TTA is a response to Captain Frangos's parallel desire to say, well, hang on a minute, I'm upset that I'm going to lose the vessel, I want a right to get it back. That is the genesis of the TTA as the judge found it. And as a response to Captain Frangos requiring that option, and Miss Frangou agreeing to afford it to him, which she didn't have to do, she was the outright owner of the vessel by Brandon after the bailout. She says, well, okay, if you want an option after 4 years to buy this back, if things are going well, then I want you to hold me harmless for anything that happens to the vessel during that 4-year period. And we say that that understanding of a coterminous relationship between clauses 1 and clause 5 informs you, as well as other indicia within the contract, about why they should be read as relating to a similar time.
But it's not just hold it harmless for anything that happens to the vessel over the period. It's and any shortfall which she suffers as a consequence of, any shortfall in relation to the bank's lending, which is the bailout.
But all cut off at the end of the option period.
Well, that's the question.
Yes, but so what I'm saying, I'm answering. I hope I'm answering your question. Why should clause 5? Why should the idea that an indemnity afforded by Captain Frangos run coterminously with the option he has to buy back the vessel? Why should that make sense? And the answer is that the very premise of this agreement was his option to buy back the TT. That's what interrupts the normal pattern post bailout. Post bailout, Miss Frangou has the vessel in Brandon. She's fully responsible for all of its losses and liabilities until she can do anything with the vessel to get out of those liabilities. But the buck stops with her no matter what.
But this isn't an agreement that's reached sort of like a year or 2 years after the bailout as a separate exercise. This is reached coterminous with the bailout, isn't it?
It's under negotiation coterminous with the bailout.
Yes, you're not suggesting we don't read this agreement in light of the bailout, the very one that's referred to as background in the agreement itself.
Of course not. But one of the differences between the parties' worldviews is whether or not the TTA is the quid pro quo for the bailout. That's my learned friend's case, which was not accepted by the judge, but which was advanced at trial and in evidence and in submission as being the relationship between the TTA and the bailout. And my client's case, which is, of course, the TTA is related to the bailout, but the quid pro quo for it, that the genesis of the TTA is not that Miss Frangou wouldn't have gone ahead with the bailout had Captain Frangos not entered into the TTA, but that because Captain Frangos was saying, as a consequence of the bailout, he wanted a right to buy the vessel back, Miss Frangou says, well, okay, if you're going to play that game, I want an indemnity for the period of time that your option lasts for, and I want you to hold me harmless for anything that goes wrong with the vessel during that time, as quite likely she expected would have happened, for the period that you're shutting me out from doing what I otherwise might do with the vessel to reduce my exposures under it. Because as perhaps has been not made clear so far about Clause 1, what it does is prevent Miss Frangou from prevent Brandon or Miss Frangou from procuring that Brandon divest itself of the vessel during that 4-year period. Now, it may be quite possible that a businesswoman like Miss Frangou might have wanted to get rid of the TT from her ownership, or from Brandon's ownership, much sooner than 4 years. If the market had taken a certain direction, she might have thought, right, I want to get out now. After only 1 year, I'm going to cut my losses. I was 5 million down to start with. Now I'm only 6 million down. I'm going to get out of this. I'm not willing to, the markets are looking bad for me. I don't want to hold on to the vessel for any longer. But she can't do that because of Clause 1 of the TTA. Her hands are tied for 4 years. So because Captain Frangos wants the vessel back after 4 years, or within 4 years, she can't use her business or commercial nous or her instincts to better her position, having been landed in the situation of the bailout against her will. And once you understand that sucker punch to Clause 1, in addition to the option, you begin to see why she might want, after 4 years, a right to have been made whole for any losses she suffered by virtue of owning Brandon that she thinks she wouldn't otherwise have had to suffer, because if she'd had a completely free hand, she would have long since sold the vessel. My lords, Mr. Hill's notifying me that it's gone 4:15. Sorry, I was getting...
You were getting ahead of steam. Is that a convenient moment?
Yes, indeed.
And how are we doing in relation to time? How much longer will you be tomorrow?
I think it'll be my full... At the moment, I think it'll be my full share of half the time that we had planned for, because I obviously have to deal with implied position.
Absolutely, you've got a lot to do, which is why I'm concerned. And I'm just thinking that in those circumstances, I think we will start at 10:15 tomorrow.
Great.
Thank you very much indeed.
All rise.